let's go see what she has to say.
Welcome, everyone. We're going to officially get started in 3 minutes, it looks like. I think Sarah's about to start recording. I did tell the early attendees, everyone will be muted except me, and we will use the chat box for questions. I think Sarah can unmute you individually if you need her to for a moment, but mainly I'll just go over whatever questions I have after we discuss each slide. We do have a number of members of the public, so we think that'll be a little more orderly. Okay, everybody, I show that it's 5 o'clock, so we'll go ahead and get started. A few housekeeping matters before we start on the presentation. We do have a number of members of the public who have joined us, so everyone will be muted, and I would ask that you present your questions in the chat box, and I will address those after each slide. I'll check for those, and that way we can kind of keep it flowing. And just another matter, this is, of course, at the request of the council members. And so it's just a very general planning and zoning presentation, high level look at some of the basics of the law. And so we will not address questions related to any individual situations or pieces of property or Maumelle anticipated business. We're just going to talk about the law itself and kind of how it came to be the way it is, and some cases and things that have developed over the last 100 or so years. So just so you know that that is what we'll be discussing and looking at tonight. I'm happy to answer your questions if I can, as long as they're related to the presentation and related to general principles. Just a little bit of background. Way back about 24 years ago, Janae Davis and I sat next to each other in a land use class in law school. So, some of this I have drawn upon Professor Bob Wright's writings and my recollections and notes from that time, but it has been a while since I studied this in depth. That course took an entire semester, 3 times a week, 3 hours a week. So just so you know, I will not cover nearly all aspects, but hopefully we'll hit upon some principles that'll be helpful. I see I have a couple of questions. Yes, the presentation will be recorded. Okay. All right. So let's talk about the basics of property rights and the police power. So the Fifth Amendment, which became effective towards the states with the 14th Amendment, it prohibits the states from taking property without just compensation. So that's why when we have situations where we have to have a right of way for a road, or we need to we need property for a public park, the city of course can't just take that. We do have to pay just compensation under eminent domain. Now, the regulation of property rights without something else doesn't entitle that owner to that same just compensation, as long as it is a proper exercise of the police power. Okay, so everything, all of our rights to regulate property and the uses of that go back to that police power. We talked about that a little bit at the council meeting the other night, and that we do need to be relying on that and using that justification. That definition of police power is the power to legislate for the health, morals, safety, and welfare of the community. So we always need to be looking at what is in the best interests of Maumelle, of our community as a whole. And we need to be focused on the big picture and what's going to be best for our city in the long run as a whole. All right, so the livery stable principle. This is pretty self-evident. This goes back to a case out of Little Rock way back in 1915. So I told you, the last 100 years or so, where they wanted to regulate where livery stables could be, because, not everybody wants to work or live next to a livery stable for obvious reasons. And they said that ordinances will generally be upheld if they meet the following tests. Number one, they protect the health, safety, or welfare of the community. We just that police power that we just talked about. It's a proper use of that police power. Number two, it's not arbitrary, capricious, or unreasonable. We didn't just decide that people who wear yellow shirts on a Wednesday aren't allowed to do, something in particular with their property. And number three, that it operates uniformly on all landowners who are similarly situated. Okay, so it goes to those sort of equal protection types of principles, that whatever regulation we are going to make and we're going to follow, we need to make sure that we're being consistent and that all of our similar landowners are subject to the very same regulation. All right, so a little bit about enabling acts. Maumelle gets its authority for zoning and planning and to create our master plan and to have our planning commission through enabling acts that the state of Arkansas has enacted that give us the ability, the right to adopt and enforce those master plans and give some guidance for how that's to be done and how that process is supposed to go. The master plan is frequently formulated by a planning commission, or there may be a special group appointed at times to do a comprehensive plan for the city that includes revisions to a master land use plan. But it has legal effect only when it's adopted by the city's governing body. So it's where our council comes into play. The council has to approve that overall master plan, and that's by ordinance. So we talked a little bit about that last week in council, that if we amend the master plan, or if we amend the zoning map, we're amending an ordinance essentially, because that's how it was originally enacted. And that enabling act is typically going to say that the same procedures that we use we require for the plan to be adopted are required for an amendment. So that's why, Scott and the staff in the planning and permits department don't just consider these at the administrative level. It has to go before the planning commission and the council. No questions? I don't have any questions at all. All right, we'll keep going. All right, so the plan, the master plan, okay? The master plan is sometimes called a comprehensive plan, and it is behind our authority for zoning and land use. That's the whole reason that our zoning regulations are valid, because it assumes that our city has engaged in this planning process, that we have this master plan, because we were looking at long range concerns. We're looking at what is our population going to look like in 30 years? How's our traffic going to be affected by different developments and where people are living? What are our employment trends going to be? Are more people going to be working from home? Are they going to be traveling to different areas of the state than where they travel to now? Will more people be working in Conway? All of those kinds of things. The master plan is meant to be planned by a group that looks at all of what they want the future of the community to be, and how they want things to flow, and what they want our community to look like long term. Zoning is really a tool used to execute that planning process, that master plan. So it's dependent, the validity of zoning is dependent on that master plan being in place. Your master plan should provide for a variety of uses in appropriate places in your community, because, we're going back to that police power. It's in the best interest of the community to have grocery stores. It's in the best interest of the community to have gas stations. It's in our interest to have boutiques and car washes and all of those things in the right location, and to plan for where is that noise going to be most appropriate and least intrusive? Where are any odors like the livery stable going to be the most appropriate and the least intrusive? So it is in the best interest of the community to provide for all those uses, but to provide for them to be in the best possible location. All right, still no questions? Okay. All right, so I wanted to touch upon spot zoning. This is something that I presented some information on in the last meeting, just some treatise discussions. And spot zoning is, by its definition, it's not valid, because it amounts to an arbitrary, capricious, and unreasonable treatment for a limited area, and it departs from that comprehensive plan. So we already said that our comprehensive plan is supposed to provide for the overall welfare, safety, morals of the community. And when we decide to change something in that comprehensive plan, it should be a very well thought out decision, and there should be some way that we reconcile that with what we want the master plan to be. It should be unusual that we do that we depart from our comprehensive plan once we have it in place. So spot zoning, an allegation of spot zoning can arise from an amendment to the zoning ordinance or variances. Sometimes people can ask for variances from different zoning code section provisions, or that it can be, in some jurisdictions, they allow special use approval. Anytime any ordinance is amended, or there's a variance, or there's some type of special use that can constitute spot zoning, even if the zoning is not technically changed. Still no questions? Okay. All right. This concept has even been extended to cities and communities that are neighbors that share common boundaries. The case that I mentioned here from 1954, there was planning that had taken place in 3 different communities, and then there was an area where they came together, and all of the zoning was pretty harmonious, and same type of uses in that boundary area. And then that one city decided that they were going to change that zoning close, at that boundary area line. And the court determined that even though even in consideration of the neighboring communities' zoning, it could still be spot zoning. You still have to live harmoniously with the zones nearby, even if they're technically in another city. So that's why we want our zoning where we meet North Little Rock out at the White Oak area and Counts Massey, that we want that to complement their zoning. And if we have a situation where everything in North Little Rock has changed and developed differently, we have made a change there in the last couple of years, because we needed to make that change to be in harmony with surrounding areas. So spot zoning isn't necessarily independent of a community that you share a boundary with. Still no questions? All right, let me see if I missed anything. All right. So when you're looking at what spot zoning is, whether a change constitutes spot zoning, you're going to look at some tests and factors that the cases have sort of developed over time. The questions here are known as the Little test, because it's from the Little case back in 1981. And these are the questions that the court's typically going to consider in deciding whether something constitutes spot zoning. They're going to look at number 1, whether the requested use is significantly different from the other prevailing uses or use in that area. Number 2, whether the area that's being rezoned is small in size, or the number of landowners benefited. So it's not a large area. It just benefits, a very small number of people, or even one person. And then number 3, whether the rezone appears to be more in the nature of special legislation designed to benefit one or a few landowners at the expense of surrounding landowners or the general public. So is it something that everything around that area is one particular type of zoning, but they're asking to be something different? Everything around it is residential, for example, and they're asking for it to be changed to commercial, and it's just one very small area. All right, I finally have a question, so let's see what it is. Okay, this is from Councilmember Gardner. In terms of spot zoning, how does this impact areas of our city where the surrounding areas has changed? For instance, an area is currently zoned commercial, but we deem it to be a better area. Sorry, I lost it when I went down. For PRD, since our city has grown differently than what was planned long ago. If we adjust certain areas, is that considered spot zoning, or a good change since it's more harmonious with the way the city has grown and changed? Well, it depends. We would look at, you would need to consider the factors that are mentioned here. We would need to consider the factors that are in our code section, and we've mentioned these before. Anytime the planning commission or the city council is going to review a change or an amendment to our master use plan, our code itself has some factors to look at. One is other changes that have occurred in the neighborhood since the land use plan was adopted or the latest amendment was enacted. So what's happened in that neighborhood or area, and what changes have taken place. B, whether these changes resulted in a change to the neighborhood's character sufficiently to justify the proposed land use plan change. C, issues and concerns raised by the neighborhood. Are there, is it at the expense of surrounding landowners? That goes along with this little test. And D, other substantial or technical evidence that any proponent or opponent of the proposed change submits. So, it's just something the city is going to consider on a case-by-case basis using those factors. But you can see that those factors that are in our code are not, those are not arbitrary factors. They are very well related to this case law. There's a reason those factors are in the code. They go right along with, the little test that we just went over. What is the prevailing use in the area? Are we benefiting the community as a whole or just one landowner? Are we rezoning a whole area? And there may be times when we consider our master plan or comprehensive land use plan as a whole, and there may be some changes that are made in that process. Let's see, it looks like I have another question. Wouldn't such changes be on the master plan since it is long-term? Well, and that's from RJ. RJ, you could do it that way. I mean, there could be an overall reconsideration of the master plan. I think our written master plan that Scott sent to me today was from maybe 2011. And we have made changes to the master plan map since then as well on a case-by-case basis. But I think that was probably the last time there was a comprehensive look at, what do we want our strategic plan to be? So typically, that's when those big changes would be made. We would look at the overall flow of the community and how we want the community to look long term. Okay. All right. This is just another principle that I wanted to talk about while we were discussing various zoning issues. And one of those is contract zoning. And that is where there's an agreement between a property owner and a local government where there are certain conditions or things that the city wants in order to promote the rezoning or support rezoning of an area. Arkansas hasn't made a ruling on contract zoning. It is discussed in that PHLLC case that I included in the council packet last time, where they discussed that they specifically declined to make a ruling on that issue. But the jurisdictions that have considered this frequently say that you're negotiating away your police power. And once you've negotiated it away, it's no longer valid. Again, we're only the regulation of zoning, the regulation of land use, again, goes back to that police power. Are we acting in the welfare, best interest, safety of our community as a whole? And it's, those that have looked at that have specifically said you shouldn't be able to negotiate that away. So that is that's an invalid zoning. All right, I see I have another question. Oh, this one's long. Okay, so this is a quote from our code section on scheduled reviews, 54-81. Scheduled reviews, the Planning Commission shall cause the land use plan to be reviewed a minimum of once every 5 years, or whenever one of the following should occur: the annexation of 640 acres or more, a population increase by more than 25% over the last recorded U.S. Census population, development occurs on more than 50% of the currently available industrial industrially zoned property. Development occurs on more than 50% of the currently available commercially zoned property. Development occurs on more than 50% of the currently available residentially zoned property. So there are provisions that we should periodically look at our land use plan and make those revisions. And that is something we do need to look at, making sure that we're keeping up with that and doing that as frequently as we should. I think that was probably the point he was trying to make there. If there's anything else that you wanted me to address with that, just let me know. All right, I wanted to say just a word about discriminatory zoning, even though this is not something we've specifically, that's really come up, but I do think it's important. There have been a number of states, particularly in New Jersey, who have made case law. Oh, shoot. Well, there we go. Let's see if I can get back on it. One second. Okay. Hopefully we're all back on the same page again. If we're not, let me know. You should be back to discriminatory zoning with me. In particular, New Jersey's made a lot of laws or a lot of case law on this issue. Arkansas, not as much. But one of the provisions there is that basically it shouldn't be zoned so that you are eliminating lower income people's chance to live in your community. So we should have a variety of zoning that includes all different types of housing. And I think Maumelle has done that, and it's been over a period of time. But we do have a variety of different housing styles, housing sizes, and so hopefully we wouldn't have any issues on that. Some of the cases have looked at situations where they didn't want to allow, townhouses at all anywhere in the city, no multifamily in the city, and that's not permitted. So that's an issue. We do want to make sure we have a variety of options in our community. One of the cases that has addressed discriminatory housing is the Mincy case, which is out of Little Rock. Or concerned to the city of Little Rock out of Arkansas, very recent. And in that case, they were looking at a rezoning request from a property owner who wanted to have like a salon type facility, I believe, in a residential area. And some of those types of zoning provisions have been changed. There have been some situations where Little Rock had allowed some people to do that in various residential areas. And so her argument was that some of the people, the neighbors that had expressed concerns had talked about a rise in crime and some things like that. And she was in a racial minority, and she believed that it was discriminatory. And the court very carefully considered those claims and looked at the legitimate concerns that have been brought out and also the consistency with other decisions. And so I did just want to mention that it's very important that we be consistent. However we're going to treat people, we need to treat people the same, and we need to be able to rely on the same principles in each situation. We need to make a good record on the factors that we talked about that are in our code. If we are going to find that, there have been other changes in the neighborhood, that there has been a change to the character of the neighborhood, that the issues and concerns raised by the neighborhood were not sufficient to, stop us from making a change or something like that. We just need to make a record on those. We need to make sure that we are articulating well the reasons for the changes that we do allow on a case-by-case basis, as opposed to looking at our overall master plan and amending it as a whole. I did it again. Okay, I guess that is my last slide. That went a lot faster than I thought it was going to be. I know you guys have some questions. I'm going to wait just a second. I'm going to see if you bring any up. Make sure, yeah. No one? Okay. Well, thanks for coming, everybody. I appreciate you all listening in. I hope this has been informative. And as always, I'm available anytime you want to give me a call. We have to go through all these hoops of recording and making sure that we don't speak about things inappropriately, of course, because we want to follow all of the rules relating to the Freedom of Information Act. Especially when you are involved in discussions with other members of your governing body. But if you have individual questions, of course, you're always welcome to call me and discuss those on an individual basis. Oh, we have a question. Okay. Give examples of arbitrary. I haven't seen a lot of case law where they specifically ruled that something was arbitrary. But basically, it would be that those factors were not considered, or the factors were discussed, but there wasn't due weight given to those factors. So if something's arbitrary, that means that we didn't consider, other changes that have occurred in the neighborhood, or we didn't look at whether the character of the neighborhood had changed, that we basically just did it without any particular reason because we decided we wanted to, help a particular landowner or, for some other reason unrelated to the health, welfare, safety of the community. Anybody else? All right. Well, I hope you guys all have a good evening. I will be at home for the next week. I have been quarantined. So if any of you need to reach me, of course, I think you almost all have my cell phone. Please feel free to reach out or email me and I'll get back in touch with you. Thanks so much.